The document below is an exact copy of the original document that Mr. John Nelson wrote on February 21, 1992, with the following exceptions. Many statements have been made bold or italicized to call out their importance. The original document had neither bold nor italic text. Spelling errors have been corrected. A paragraph has been added to the original document and identifies itself as being such. Some of the references by this document to other documents are now hyperlinks to those other documents, so you can review those other documents also if you want to. John B. Nelson. 2. The American National People, the People of the State of Colorado, USA, February 21, 1992. Declaration of Cause and Necessity to Abolish and Declaration of Separate and Equal Station. I have enclosed Senate Report No. 93-549, 93rd Congress, First Session 1973, Summary of Emergency Power Statutes, consisting of 607 pages, which I believe you will find most interesting. The United States went bankrupt in 1933 and was declared so by President Roosevelt by Executive Orders 6073, 6102, 6111 and by Executive Order 6260 on March 9, 1933. See Senate Report 93-549, pgs. 187 and 594, under the Trading with the Enemy Act, 65th Congress, Sess. I.Ch.'s. 105, 106, October 5, 1917, and is codified at 12 U.S.C.A. 95A. On May 23, 1933, Congressman Louis T. McFadden brought formal charges against the Board of Governors of the Federal Reserve Bank System, the Comptroller of the Currency and the Secretary of the United States Treasury for criminal acts. The petition for articles of impeachment was thereafter referred to the Judiciary Committee, and has yet to be acted upon. See Congressional Record, pp. 4055-4058. Congress confirmed the bankruptcy on June 5, 1933, and impaired the obligations and considerations of contracts through the joint resolution to suspend the gold standard and abrogate the gold clause. June 5, 1933. See House Joint Resolution 192, 73rd Congress, First Session. The several states of the Union pledged the faith and credit thereof to the aid of the national government, and formed numerous socialist committees, such as the Council of State Governments, Social Security Administration, etc., to purportedly deal with the economic emergency. These organizations operated under the Declaration of Interdependence of January 22, 1937, and published some of their activities in the Book of the States. The 1937 edition of the Book of the States openly declared that the people engaged in such activities as the farming, husbandry 706. Industry had been reduced to mere feudal tenants on their land. Book of the States, 1937, pg. 155. This of course was compounded by such activities as price-fixing wheat and grains 7 U.S.C.A. 1332, quota regulations 7 U.S.C.A. 1371, and livestock products 7 U.S.C.A. 1903, which have been consistently below the costs of production, interest on loans and inflation of the paper bills of credit, leaving the food producers and others in a state of peonage and involuntary servitude, constituting the taking of private property, for the benefit and use of others, without just compensation. Note, the Council of State Governments has now been absorbed into such things as the National Conference of Commissioners on Uniform State Laws, whose headquarters office is located at 676 North Street, Clare Street, Suite 1700 Chicago, Illinois 60611, and all being members of the bar, and operating under a different constitution and by laws, far distant from the depositories of the public records, has promulgated, lobbied for, passed, adjudicated and ordered the implementation and execution of their purported uniform and model acts and pretended statutory provisions to help implement international treaties of the United States or where world uniformity would be desirable. See 1990-91 Reference Book, National Council of Commissioners on Uniform State Laws, pg. 2. This is apparently what Robert Bork meant when he wrote, "We are governed not by law or elected representatives but by an unelected, unrepresentative, unaccountable committee of lawyers applying no will but their own." See The Tempting of America, Robert H. Bork, pg. 130. This association has been engaged in activities such as turning marriage licensed into international private law through its international liaisons, which meet at such places as the Hague Conferences. See Handbook of Commissioners on Uniform State Laws, 1966 ed. pg. 156 to 157. On April 25, 1938, the Supreme Court overturned the standing precedents of the prior 150 years concerning common law in the federal government. There is no federal common law, and Congress has no power to declare substantive rules of common law applicable in a state, whether they be local or general in their nature, be they commercial law or a part of the law of torts. See Erie Railroad Co. vs. Tompkins, 304 U.S. 64, 82 L. ed. 1188. The common law is the fountain source of substantive and remedial rights, if not our very liberties. See Stephen, A Treatise on the Principles of Pleading, Introduction, pg. 23, Hemingway, History of Common Law Pleading as Evidence of the Growth of Individual Liberty and Power of the Courts, 5 Alabama Law Journal 1, Swift vs. Tyson, 16 Peters 1, 10 L. ed. 865, Constitution, Article 3, Section 2, Amendments 7, Ix and X. The members and association of the bar thereafter formed committees, granted themselves special privileges, immunities and franchises, and held meetings concerning the judicial procedures, and further, to amend laws to conform to a trend of judicial decisions or to accomplish similar objectives, including hodgepodging the jurisdictions of law and equity together, which is known today as one form of action. See Constitution and Bylaws, Article 3, Section 3.3 c. 1990-91 Reference Book, Supra. See also, Colorado Methods of Practice, West Pub, Vol. 4, pgs. 2-3, Author's Comments. Note, the enumerated, specified and distinct jurisdictions established by the ordained Constitution 1789, Article 3, Section 2, and under the Bill of Rights 1791, Amendment 7, were further hodgepodged and fundamentally changed in 1982 to include admiralty jurisdiction, which was once again brought inland. This is the fundamental change necessary to effect unification of civil and admiralty procedure. Just as the 1938 rules abolished the distinction between actions at law and suits in equity, this change would abolish the distinction between civil actions and suits in admiralty. Federal Rules of Civil Procedure, 1982 ed. pg. 17, also see, Federalist 707. Papers No. 83, Declaration of Resolves of the First Continental Congress, October 14, 1774, Declaration of Cause and Necessity of Taking Up Arms, July 6, 1775, Declaration of Independence, July 4, 1776, Bennett vs. Butterworth, 52 U.S. 669. The United States thereafter entered the Second World War, during which time the League of Nations was reinstituted under pretense of the United Nations, c. 22 U.S.C.A. 287 et. Seq., and the Bank for International Settlements reinstituted under pretense of the Bretton Woods Agreement, c. 60 Stat. 1401, 22 U.S.C.A. 286 et. Seq., as the International Monetary Fund, the Fund, and the International Bank for Reconstruction and Development, the Bank. The United States as a corporate body politic artificial came out of World War II in worse economic shape than when it entered, and in 1950 declared bankruptcy and reorganization. The reorganization is located in Title V of United States Codes Annotated. The explanation at the beginning of 5 USCA is most informative reading. The Secretary of Treasury was appointed as the receiver in bankruptcy. See Reorganization Plan No. 26, 5 USCA 903, Public Law 94-564, Legislative History, pg. 5967. The United States went down the road and periodically filed for further reorganization. Things and situations worsened, having done what they were commanded not to do. See Madison's Notes, Constitutional Convention, August 16, 1787, Federalist Papers No. 44, and in 1965 passed the Coinage Act of 1965, completely debasing the constitutional coin, gold and silver, i.e. dollar. See 18 USCA 331 and 332, U.S. vs. Marigold, 50 U.S. 560, 13 L. ed. 257. At the signing of the Coinage Act on July 23, 1965, then-President Lyndon B. Johnson stated in his press release that, "When I have signed this bill before me, we will have made the first fundamental change in our coinage in 173 years." The Coinage Act of 1965 supersedes the Act of 1792. And that act had the title, "An Act Establishing a Mint and Regulating the Coinage of the United States." Now I will sign this bill to make the first change in our coinage system since the 18th century. To those members of Congress, who are here on this historic occasion, I want to assure you that in making this change from the 18th century we have no idea of returning to it. It is important to take cognizance of the fact that no constitutional amendment was ever obtained to fundamentally change, amend, abridge or abolish the constitutional mandates, provisions or prohibitions, but due to internal and external diversions surrounding the Vietnam War etc., the usurpation and breach went basically unchallenged and unnoticed by the general public at large, who became a wealthy man's cannon fodder or cheap source of slave labor. See, Silent Weapons for Quiet Wars, TMSW 7905.1, PGS. 6, 7, 8, 9, 12, 13 and 56. Congress was clearly delegated the power and authority to regulate and maintain the true and inherent value of the coin within the scope and purview of Article 1, Section 8, Clauses 5 and 6 and Article 1, Section 10, Clause 1, of the ordained Constitution 1787, and further, under a corresponding duty and obligation to maintain said gold and silver coin and foreign coin at and within the necessary and proper equal weights and measures clause. See also, Bible, Deuteronomy, chapter 25, verses 13 through 16, Proverbs, chapter 16, verse 11, Public Law 97 to 289, 96 Stat. 1211. Those exercising the offices of the several states, in equal measure, knew such de facto transitions were unlawful and unauthorized, but sanctioned, implemented and enforced the complete debauchement and the resulting governmental, social, industrial economic change in the de jure states and in United States of America. See, Public Law 94 to 564, Legislative History, pg. 5936, 5945, 31 U.S.C.A. 314, 31 U.S.C.A. 321, 31 U.S.C.A. 5112, CRS. 11-61-101 CRS. 39 to 22-103.5 and CRS. The 18th of November 203, and were and are now under the delusion that they can do both directly and indirectly what they were absolutely prohibited from doing. See, also, Federalist Papers No. 44, Craig vs. Missouri, 4 Peters 903. 708. In 1966, Congress, being severely compromised, passed the Federal Tax Lien Act of 1966, by which the entire taxing and monetary system, i.e., essential engine, see Federalist Papers No. 31, was placed under the Uniform Commercial Code. See Public Law 89 to 719, Legislative History, pg. 3722. Also see CRS. The 1st of May 106. The Uniform Commercial Code was of course promulgated by the National Conference of Commissioners on Uniform State Laws in collusion with American Law Institute for the Banking and Business Interests. See, Handbook of the National Conference of Commissioners on Uniform State Laws. 1966 ed., pgs. 152 and 153. The United States being engaged in numerous United Nations conflicts, including the Korean and the Vietnam conflicts, which were under direction of the United Nations, see 22 U.S.C.A. 287d, and agreeing to foot the bill, see 22 U.S.C.A. 287j, and not being able to honor their obligations and rehypothecated debt credit, openly and publicly dishonored and disavowed their notes and obligations 12 U.S.C.A. 411, i.e. Federal Reserve Notes through Public Law 90 to 269, Section 2, 82 Stat. 50, 1968 to wit, Sec. 2. The first sentence of Section 15 of the Federal Reserve Act 12 U.S.C. 391 is amended by striking and the funds provided in this act for the redemption of Federal Reserve notes. Things steadily grew worse, and on March 28, 1970, then-President Nixon issued Proclamation No. 3972, declaring an emergency because the postal employees struck against the de facto government for higher pay due to inflation of the paper bills of credit. See Senate Report No. 93 to 549, pg. 596. Nixon placed the U.S. Postal Department under the control of the Department of Defense. See Department of the Army Field Manual, FM 41-10, 1969 ed. The system had been faltering for a decade, but the benchmark date of the collapse is put at August 15, 1971. On this day, then-President Nixon reversed U.S. international monetary policy by officially declaring the non-convertibility of the U.S. dollar, the Federal Reserve Note (FRN), into gold. See Public Law 94-564, Legislative History, pg. 5937 and Senate Report No. 93 to 549, Forward, pg. 3, Proclamation No. 4074, pg. 597, 31 U.S.C.A. 314 and 31 U.S.C.A. 5112. On September 21, 1973, Congress passed Public Law 93-110, amending the Bretton Woods Par Value Modification Act, 82 Stat. 116, 31 U.S.C.A. 449, and reiterated the emergency 12 U.S.C.A. 95A, and Section 8 of the Bretton Woods Agreements Act of 1945, 22 U.S.C.A. 286F, and which included reports on foreign currency transactions. Also see, Executive Order No. 10,033. This act further declared in Section 2(b) that, no provision of any law in effect on the date of enactment of this act, and no rule, regulation, or order under authority of any such law, may be construed to prohibit any person from purchasing, holding, selling, or otherwise dealing with gold. On January 19, 1976, Marjorie S. Holt noted for the record, a second Declaration of Interdependence and clearly identified the UN as a communist organization, and that they were seeking both production and monetary control over the Union and people through international organization promoting the One World Order. See Congressional Record, January 19, 1976, Extension of Remarks. Also see 8 U.S.C.A. 1101, 40, 50 U.S.C.A. 781 and 783. The socio-economic situation worsened as noted in the complaint petition filed in the U.S. Court of Claims, docket No. 41-76, on February 11, 1976, by 44 federal judges. Atkins et al. Versus U.S. Atkins et al. Complained that, as a result of inflation, the compensation of federal judges has been substantially diminished each year since 1969, causing direct and continuing monetary harm to plaintiffs. The real value of the dollar FRNs decreased by approximately 34.5% from March 15, 1969 to October 1, 1975. As a result, plaintiffs have suffered an unconstitutional deprivation of earnings, and in the prayer for relief claimed damages for the constitutional violations enumerated above, measured as the diminution of his earnings for the entire period since March 9, 1969. It is quite apparent that the persons holding and enjoying offices of public trust, honor and/or profit knew of the emergent problem and sought protection for themselves, to the damage and injury of the people and children, who were classified as a club that has many other members who have 709. No remedy. And knowing that heinous acts had been committed, stated that they judges, lawyers would not apply the law, nor would any substantive remedy be applied, checked more or less, but never stopped until all of us judges are dead. Such persons fraudulently swore an oath to uphold, defend and preserve the sovereignty of the nation and several Republican states of the Union, and breached the duty to protect the people, citizens and their posterity from fraud, imposition, avarice and stealthy encroachment. See, Atkins et al. Versus U.S. 556 F2D 1028, pg. 1072, 1074, The Tempting of America, Supra, pgs. 155-159. Also see, 5 U.S.C.A. 5305 and 5335, Senate Report No. 93-549, pgs. 69-71, CRS. 24-75-101. This is verified in Public Law 94-564, Legislative History, pg. 5944, which states, moving to a floating exchange rate for international commerce means private enterprise and not central governments bear the risk of currency fluctuations. Numerous serious debates were held in Congress, including but not limited to, Tuesday, July 27, 1976, c. Congressional Record, House, July 27, 1976, concerning the international financial institutions and its operations. Representative Ron Paul, chairman of the House Banking Committee, made numerous references to the true practices of the international financial institutions, including but not limited to, the conversion of 27 million in gold, contributed by the United States as part of its quota obligations, which the International Monetary Fund Governor-Secretary of Treasury sold. See Public Law 94-564, Legislative History, pg. 5945 and 5946, under some very questionable terms and concessions. Also see, the Ron Paul Money Book, 1991, by Ron Paul, Plantation Publishing, 837 W. Plantation, Clute, Texas 77531. On October 28, 1977, the passage of Public Law 95-147, 91 Stat. 1227 declared most banking institutions, including state banks, to be under direction and control of the corporate governor of the International Monetary Fund. See Public Law 94-564, Legislative History, pg. 5942, United States Government Manual 1990-91, pgs. 480-481. The Act further declared that, 2 Section 10 of the Gold Reserve Act of 1934 31 U.S.C. 822 b is amended by striking out the phrase "stabilizing the exchange value of the dollar." C. The joint resolution entitled Joint Resolution to Assure Uniform Value to the Coins and Currencies of the United States, approved June 5, 1933 31 U.S.C. 463 shall not apply to obligations issued on or after the date of enactment of this section. The international organizations, corporations and associations, had refused to pay their debts and could not pay their debts, and determined that they could pass the loss of their non-redeemable, non-current notes, bonds and evidences of debt off on others, and thereby crown their fraud with success. See Letter, October 26, 1989 from Department of Treasury, Russell L. Monk, Assistant General Counsel, International Affairs, as recorded in the Office of Clerk and Recorder, Baca County, Colorado, at Book 540 page 364. The de facto United States as Corporator, 22 U.S.C.A. 286e, ed. seq., and State CRS. 24-36-104, CRS. 24-60-1301, Article 4 H had declared insolvency. C. 26 IRC 165 G 1, UCC 1-201-23, CRS. 39-22-103.5, Westfall vs. Browley. 10 Ohio 188-75, Am. Dec. 509, Adams vs. Richardson, 337 SW2D 911 Ward vs. Smith, 7 Wall 447. In 1980 Congress passed, among other things, Public Law 96-221, providing for the furtherance and expansion of the profligate rehypothecated debt pyramid scheme, and reduced the reserve requirements on transaction accounts to a minimum of 3% per centum to a maximum of 14 per centum. See Depository Institutions Deregulation and Monetary Control Act of 1980, Section 103 B.E. 2. 710. In the United States, neither paper currency nor deposits have value as commodities. Intrinsically, a dollar bill is just a piece of paper. Deposits are merely book entries. Coins do have some intrinsic value as metal, but generally far less than their face amount. Compare this with the United States Constitution, which says, "No state shall make anything but gold and silver coin a tender in payment of debt," and which also says, "Congress shall have the power to coin money and regulate the value thereof." Italics added for emphasis, this paragraph added to the original John B. Nelson document of February 21, 1992 on July 18, 1999 to reiterate what was stated previously in this document and to demonstrate, firsthand, yet another way the Constitution is being usurped, in fact and in intent. In the absence of legal reserve requirements, banks can build up deposits by increasing loans and investments so long as they keep enough currency on hand to redeem whatever amounts the holders of deposits want to convert into currency. This unique attribute of the banking business was discovered several centuries ago. At one time, bankers were merely middlemen. They made profit by accepting gold and coins brought to them for safekeeping and lending them to borrowers. But they soon found that the receipts they issued to depositors were being used as money, since whoever held them could go to the banker and exchange them for metallic money. Then bankers discovered that they could make loans merely by giving borrowers their promises to pay bank notes. In this way, banks began to create money. More notes could be issued than the gold and coin on hand because only a portion of the notes outstanding would be presented for payment at any one time. Enough metallic money had to be kept on hand, of course, to redeem whatever volume of notes was presented for payment. Transaction deposits are the modern counterpart of bank notes. It was a small step from printing notes to making book entries to the credit of borrowers, which the borrowers, in turn, could spend by writing checks, thereby printing their own money. See Modern Money Mechanics, a workbook on deposits, currency and bank reserves, 1982. Reverend ed., Federal Reserve Bank of Chicago, P.O. Box 834, Chicago, Illinois 60690, PGS. 3 and 4. 59 years is not temporary. It's a permanent state of emergency, and was clearly instituted, formed and erected within the Union through gross usurpations, abridgments, malfeasance and breach of legal duties, and the continual contrivance, misrepresentation, conversion, fluctuations, fraud and avarice of the international financial institutions, organizations, corporations and associations, including the Federal Reserve, their fiscal and depository agent. 22 U.S.C.A. 286d. This profligate practice has led to such emergency legislation as the Public Debt Limit Balance Budget and Emergency Deficit Control Act of 1985, Public Law 99-177, etc. The government, by becoming a corporator, c. 22 U.S.C. 286e, lays down its sovereignty and takes on that of a private citizen. It can exercise no power which is not derived from the corporate charter. See the Bank of the United States vs. Planters Bank of Georgia, 6L ed. 9 Wheat 244, U.S. vs. Burr, 309 U.S. 242. The real party in interest is not the de jure United States of America or state, but the bank and the fund. 22 U.S.C.A. 286, et seq. Crs. 1160-103. The acts committed under fraud, force and seizures are many times done under letters of marque and reprisal, i.e. recapture. See 31 U.S.C.A. 5323. Such principles as fraud and justice never dwell together, Wingate's Maxims 680, and a right of action cannot arise out of fraud. Broom's Maxims 297, 729, Cowper's Reports 343, 5 Scott's New Reports 558, 10 Mass. 276, 38 Fed. 800, are too high of a thought concept, as is due process, just compensation and justice itself. Honor is earned by honesty and integrity, not under false and fraudulent pretenses, nor will the color of the cloth one wears cover up the usurpations, lies, trickery and deceits. When black is fraudulently declared to be white, not all will live in darkness. As astutely observed by Will Rogers, there are men running 711 governments who shouldn't be allowed to play with matches, and is as applicable today as Jesus' statements about lawyers. The contrived emergency has created numerous abuses and usurpations, and abridgments of delegated powers and authority. As stated in Senate Report 93-549, since March 9, 1933, the United States has been in a state of declared national emergency. In fact, there are now in effect 4 precedentially proclaimed states of national emergency, in addition to the national emergency declared by President Roosevelt in 1933. There are also the national emergency proclaimed by President Truman on December 16, 1950, during the Korean conflict, and the states of national emergency declared by President Nixon on March 23, 1970, and August 15, 1971. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the President extraordinary powers, ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers, taken together, confer enough authority to rule the country without reference to normal constitutional process. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. See Forward, pg. 3. The introduction, on page 1, begins with a phenomenal declaration, to wit, a majority of the people of the United States have lived all of their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. According to the research done in 16 American Jurisprudence, 2nd edition, sections 71 and 82, no emergency justifies a violation of any constitutional provision. Arguenda, supremacy clause, and separation of powers, it is clearly admitted in Senate Report No. 93 to 549 that abridgment has occurred. The statements heard in the federal and state tribunals, on numerous occasions, that constitutional arguments are immaterial, frivolous, etc., is based upon the concealment, furtherance and compounding of the frauds and emergency created and sustained by the expatriated, aliens of the United Nations and its organizations, corporations and associations. See, Letter, Insight Magazine, February 18, 1991, pg. 7. Lowell L. Flanders, President, UN Staff Union, New York 8 U.S.C.A. 1481 is one of the controlling statutes on expatriation, as is 22 U.S.C.A. 611, 612 and 613 and 50 U.S.C.A. 781. The Internal Revenue Service entered into a service agreement with the U.S. Treasury Department. See Public Law 94-564, Legislative History, pg. 5967, Reorganization Plan No. 26 and the Agency for International Development, pursuant to Treasury Delegation Order No. 91. The Agency for International Development is an international paramilitary operation. See Department of the Army Field Manual, 1969 FM 41-10, PGS. 1-4, Sec. 1-7 B and 1-6, Section 1-10 7 C 1, 22 U.S.C.A. 284, and includes such activities as assumption of full or partial executive, legislative, and judicial authority over a country or area. See FM 4110, pg. 1-7, Section 110 7 C 4. Also see, Agreement between the United Nations and the United States of America regarding the headquarters of the United Nations, Section 7 D and 8, 22 U.S.C.A. 287 1979 ed. at pg. 241. It is to be further observed that the agreement regarding the headquarters district of the United Nations was not agreed to. See Congressional Record, Senate, December 13, 1967, Mr. Thurmond, and is illegally in the country in the first instant. 712. The international organizational intents, purposes and activities include complete control of public finance, i.e. control, supervision, and audit of indigenous fiscal resources, budget practices, taxation, expenditures of public funds, currency issues, and banking agencies and affiliates. See FM 41-10, PGS.2-30 through 2-31, Section 251. Public finance. This of course complies with Silent Weapons for Quiet Wars Research Technical Manual TMSW 7905.1, which discloses a declaration of war upon the American people. See pg. 3 and 7, monetary control by the internationalist, through information etc. solicited and collected by the Internal Revenue Service. See TMSW 7905.1, pg. 48, also see 22 U.S.C. 286 and Executive Order No. 10033, 26 U.S.C. 6103 K4 and who is operating and enforcing the seditious international program. See TMSW 7905.1, pg. 52. The 1985 edition of the Department of Army Field Manual, FM 41-10 further describes the international civil affairs operations. At page 3-6 it is admitted that the AID is autonomous and under direction of the International Development Cooperation Agency, and at page 3-8 that the operation is paramilitary. The international organization's intents and purposes was to promote, implement, and enforce a dictatorship over finance in the United States. See Senate Report No. 93-549, pg. 186. It appears from the documentary evidence that the Internal Revenue Service agents, etc., are agents of a foreign principal within the meaning and intent of the Foreign Agents Registration Act of 1938. They are directed and controlled by the corporate governor of the Fund A.K.A. Secretary of Treasury. See Public Law 94-564, Supra, pg. 5942, U.S. Government Manual 1990-91, pgs. 480 and 481, 26 U.S.C.A. 7701, 11, Treasury Delegation Order No. 150-10, and the corporate governor of the bank. 22 U.S.C.A. 286 and 286A, acting as information service employees. 22 U.S.C.A. 611 C.E., and have been and do now solicit, collect, disburse or dispense contribution tax pecuniary contribution, Black's Law Dic. 5th ed., loans, money or other things of value for or in interest of such foreign principal 22 U.S.C.A. 611 C.E., and they entered into agreements with a foreign principal pursuant to Treasury Delegation Order No. 91 i.e. the Agency for International Development. See 22 U.S.C.A. 611 C.2. The Internal Revenue Service is also an agency of the International Criminal Police Organization, and solicits and collects information for 150 foreign powers. See 22 U.S.C.A. 263A, the United States Government Manual, 1990-91, pg. 385, see also, the Ron Paul Money Book, pg. 250-251. It should be further noted that Congress has appropriated, transferred, and converted vast sums to foreign powers, see 22 U.S.C.A. 262 c.b., and has entered into numerous foreign taxing treaties conventions, see 22 U.S.C.A. 285 grams, 22 U.S.C.A. 287J, and other agreements, which are solicited and collected pursuant to 26 IRC. 6103 K4. Along with the other documentary evidence submitted herewith, this should absolve any further doubt as to the true character of the party. Such restrictions as for the general welfare and common defense of the United States, see Constitution 1787, Article 1, Section 8, Clause 1, apparently aren't applicable, and the fraudulent rehypothecated debt credit will be merely added to the insolvent nature of the continual emergency, and the reciprocal socio-economic repercussions laid upon present and future generations. Among other reasons for lack of authority to act, such as a foreign agent's registration statement, 22 U.S.C.A. 612 and 18 U.S.C.A. 219 and 951, military authority cannot be imposed into civil affairs. See Department of the Army Pamphlet 27100-70, Military Law Review, Volume 70. The United Nations Charter, Article 2, Section 7, further prohibits the UN from intervening in matters which are essentially within the domestic jurisdiction of any state. Korea, Vietnam, Ethiopia, Angola, Kuwait, etc., are evidence enough of the bad faith of the United Nations and its organizations, corporations and associations, not to mention the seizing of 2 day-care centers in the state of Minnesota by their agents, and holding the children as collateral, hostages for payment, ransom of their fraudulent, dishonored, rehypothecated debt credit, worthless securities. Such is the rule of law as envisioned by the founders of the United Nations. Such as communist terrorism, despotism and tyranny. All were and are outlawed here. I hope this communication finds you well and mentally strong for the occasion. It is quite apparent that the treasonous and seditious are brewing up a storm of untold magnitude. Bush's public address of September 11, 1991, see Weekly Compilation of Presidential Documents, should further qualify what is being said. 713. Here. He admitted interdependence. See also Public Law 94 to 564, Legislative History, pg. 5950, One World Order. See also Extension of Remarks, January 19, 1976, Marjorie S. Holt, 8 USCA 1101, 40, Affiliation and Collusion with the Soviet Union Oligarchy, 50 USCA 781, Direction by the UN, 22 USCA 611, etc. You might also find it interesting that Treasury Delegation Order No. 92 enclosed states that the IRS is trained under direction of the Division of Human Resources (UN) and the Commissioner International by the Office of Personnel Management. In the 1979 edition of 22 USCA 287, the United Nations, at pg. 248, you will find Executive Order No. 10422. The Office of Personnel Management is under direction of the Secretary-General of the United Nations. And as stated previously, the IRS is also a member in a 150 nation pact called the International Criminal Police Organization, found at 22 USCA 263a. The Memorandum and Agreement between the Secretary of Treasury, Corporate Governor of the Fund, and the Bank, and the Office of the U.S. Attorney General would indicate that the Attorney General and his associates are soliciting and collecting information for foreign principals. See, also, the United States Government Manual 1990-91, pg. 385, also see, the Ron Paul Money Book, Supra, pg. 250, 251, 26 IRC 7401. It is worthy of note that an attorney representative is required to file a Foreign Agents Registration Statement pursuant to 22 USCA 611 C1 IV and 612, if representing the interests of a foreign principal or power. See 22 USCA 613, Rabinowitz vs. Kennedy, 376 U.S. 605, 11 L. ed. 2D 940, 18 USCA 219 and 951. On January 17, 1980, the President and Senate confirmed another constitution, namely, the Constitution of the United Nations Industrial Development Organization, found at Senate, Treaty Document No. 97-19, 97th Congress, First Session. A perusal of this foreign constitution should more than qualify the internationalist intents. The preamble, Article 1, Objectives, and Article 2, Functions, clearly evidences their intent to direct, control, finance and subsidize all natural and human resources and agro-related as well as basic industries, through dynamic social and economic changes, with a view to assisting in the establishment of a new international economic order. The high-flown rhetoric is obviously of communist origin and intents. An unelected, unrepresentative, unaccountable oligarchy of expatriates and aliens, who fraudulently claim in the preamble that they intend to establish rational and equitable international economic relations, yet openly declared that they no longer stabilize the value of the dollar nor assure the value of the coin and currency of the United States, is purely misrepresentation, deceit and fraud. See Public Law 95-147, 91 Stat. 1227, at pg. 1229. This was augmented by Public Law 101-167, 103 Stat. 1195, which discloses massive appropriations of rehypothecated debt credit for the general welfare and common defense of other foreign powers, including communist countries of satellites, international control of natural and human resources, etc., etc. A resource is a claim of property and when related to people constitutes slavery. It is now necessary to ask which constitution they are operating under. The Constitution for the New States of the United States, which was located at Liberty Lobby, 300 Independence Avenue, Southeast Washington, D.C. 20003, was the subject matter of the book entitled The Emerging Constitution by Rexford G. Tugwell, which was accomplished under the auspices of the Rockefeller Tax-Exempt Foundation called the Center for the Study of Democratic Institutions. The people and citizens of this nation were forewarned against formation of democracies. Democracies have ever been the spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. See Federalist Papers No. 10. Also see, the law, Frederick Bastiat, Code of Professional Responsibility, Preamble. This alien constitution, however, has nothing to do with democracy in reality. It is the basis of and for a despotic, tyrannical oligarchy. Article 1, Rights and Responsibilities, Sections 1 and 15 evidence their knowledge of the emergency. The rights of expression, communication, movement, assembly, petition and habeas corpus are all accepted from being exercised under and in a declared emergency. The Constitution for the New States of America openly declares, among other seditious things and delusions, that until each indicated change in the government shall 714 have been completed, the provisions of the existing Constitution and the organs of government shall be in effect. See Article 12, Section 3. All operations of the national government shall cease as they are replaced by those authorized under this Constitution. See Article 12, Section 4. This is apparently what Berger was promoting in 1976, after he resigned as Supreme Court Justice and took up the promotion of a constitutional convention. No trial by jury is mentioned, just compensation has been removed, along with being informed of the nature and cause of the accusation, etc., and everyone will of course participate in the democracy. This constitution is but a reiteration of the communist doctrines, intents and purposes, and clearly establishes a police power state, under direction and control of a self-appointed oligarchy. Apparently the present operation of the de facto government is under foreign, alien constitutions, laws, rules and regulations. The overthrow of the essential engine declared in and by the ordained and established Constitution for the United States of America 1787, and by and under the Bill of Rights 1791 is obvious. The covert procedure used to implement and enforce these foreign constitutions, laws, procedures, rules, regulations, etc., has not, to my knowledge, been collected and assimilated nor presented as evidence to establish seditious collusion and conspiracy. Fortunately and unfortunately in my land it is necessary to seek, obtain and present evidence to sustain a conviction and/or judgment. Our patience and tolerance for those who pervert the very necessary and basic foundations of society has been pushed to insufferable levels. They have fundamentally changed the form and substance of the de jure republican form of government, exhibited a willful and wanton disregard for the rights, safety and property of others, evinced a despotic design to reduce my people to slavery, peonage and involuntary servitude, under a fraudulent, tyrannical, seditious foreign oligarchy, with intent and purpose to institute, erect and form a dictatorship over the citizens and our posterity. They have completely debauched the de jure monetary system, destroyed the livelihood and lives of thousands, aided and abetted our enemies, declared war upon us and our posterity, destroyed untold families and made homeless over 750,000 children in the middle of winter, afflicted widows and orphans, turned sodomites loose amongst our young, implemented foreign laws, rules, regulations and procedures within the body of the country, incited insurrection, rebellion, sedition and anarchy within the de jure society, illegally entered our land, taken false oaths, entered into seditious foreign constitutions, agreements, pactions, confederations, and alliances, and under pretense of emergency, which they themselves created, promoted and furthered, formed a multitude of offices and retained those of alien allegiance to perpetuate their frauds and to eat out the substance of the good and productive people of our land, and have arbitrarily dismissed and held mock trials for those who trespassed upon our lives, liberties, properties and families and endangered our peace, safety, welfare and dignity. The damage, injury and costs have been higher than mere money can repay. They have done what they were commanded not to do. The time for just correction is now. Sincere consideration of presentment to a grand jury under the ordained and established Constitution for the United States of America 1787, Amendment V is in order. Numerous high crimes and misdemeanors have been committed under the Constitution for the United States of America, and laws made in pursuance thereof, and under the Constitution for the State of Colorado, and the laws made in pursuance thereof, and against the peace and dignity of the people, including but not limited to, CRS the 18th of November 203, which defines and prescribes punishment for seditious associations, which is applicable to the other constitutions, and the intents and professed purposes of their organizations, corporations and associations. If the presentment should be obstructed by the members of the bar, arrest them. I could go on, but the story is long. I hope this information and research is of assistance to you. Much remains to be uncovered and disclosed, as it is necessary and imperative to secure the lives, liberties, property, peace and dignity of the people and our posterity. Good hunting and the good Lord be with you in all your endeavors. God bless. 715. Blank, John Nelson, Juri Soli, Juri Sanguinis, Juri Coronia c. 14675 Co., Road 35.6 Mancos, Colorado, USA Testi Mapso. P.S. In addition, I am yet expecting a copy of the Service Agreement, TDO 91. It was located in the Department of Treasury, Office of the Assistant General Counsel, International Affairs, Russell L. Monk, 1500 Pennsylvania Avenue Northwest, Washington, D.C., 20220. Efforts are being made to obtain a copy, but so far have been obstructed by the bar. If anyone knows where and how a copy can be obtained, please do so immediately. The documents are necessary and imperative. It ought to be most informative. By the way, it's against the law for an insolvent to make a loan or to try to fraudulently collect thereon. See, Neal et al. Versus Clark, 251 p2d 903. It should be further noted that an alien or denizen cannot sit on a jury. See 3 Am. Ur. 2d 40, nor hold a public office. Also see 50 U.S.C.A. 781 9 and 842, and any who have expatriated c. 8 U.S.C.A. 1481 are required to make application for naturalization. The out-of-court, ex parte, summary determinations upon matters in issue is purely administrative procedure. See 1 Am. Ur. 2d 78. The jury, if any, is reduced to an advisory jury position, and is more than likely arrayed as a homage jury. 5 U.S.C. as 701-703 should be of interest concerning judicial review of agency actions. It can be found in most states under such headings and acts as the Administrative Procedures Act or the Administrative Reorganization Act. See CRS. The 24th of April 106. The de facto federal, international chartered institutions, their officers, employees, servants, agents and representatives are subject to and should be turned over to a court of law for prosecution, trial, and judgment according to law. See Pope MFG. Co. vs. Gormley, 144 U.S. 414, at pg. 419, also see 22 U.S.C.A. 286 grams. Fraud vitiates the most solemn contracts, documents and even judgments. U.S. vs. Throckmorton, 98 U.S. 61, at pg. 65. I believe that the statement made in Cohen vs. Virginia, 6 Wheat 264, 5 L. ed. 257 1821 is more than worthy of note. We courts have no more right to decline the exercise of jurisdiction which is given, that to usurp that which is not given. The one or the other would be treason to the Constitution. Also see, U.S. vs. Will, 449 U.S. 200, 66 L. ed. 2d 392, at pg. 406. Asterisk 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 asterisk. 716. Declaration of separate and equal station when in the course of human events. Whenever any form of government becomes destructive. When a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty. Declaration of Independence, Enabling Act, Section 4. No political truth is of greater intrinsic value. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether hereditary, self-appointed, or elective, may be justly pronounced the very definition of tyranny. Federalist Papers No. 47. If a nation expects to be ignorant and free, in a state of civilization, it expects what never was and never will be. The functionaries of every government have propensities to command at will the liberties and property of their constituents. There is no safe deposit for these but with the people themselves, nor can they be safe with them without information. The Writings of Thomas Jefferson, Albert E. Berg ed., Vol. 14 pg. 384. One cannot make agreements with Sodomites, Babylonians and or Satanics. Their words, oaths or signatures are of no meaning or value, their intent and purpose is to deceive, cheat, steal, lie, defraud and destroy. The seditious covert conspiracy and collusion of certain organizations, corporations and associations to damage, injure, oppress, threaten, intimidate and enforce their fraudulent, foreign, socialist, communist, democracy and foist their delusions upon the citizens and children of this land, and to corrupt the de jure public offices established to accomplish the purposes set forth in the preamble to the ordained and established Constitution as cause and necessity enough. Once again finding our safety, happiness and liberties to be in imminent danger, it has become necessary and imperative to our rights, duties, privileges, immunities, lives, liberties and property and that of our posterity, to declare our separate and equal station, and exercise our right and duty to throw off and abolish the form and operation of the de facto, fraudulent, seditious state. See Constitution for the State of Colorado, Article 2, Section 2, Declaration of Independence 1776, Constitution for the United States of America, Amendments X and X, CRS 24-60-1301, Article 4 H. Section 2. People may alter or abolish form of government, proviso. The people of this state have the sole and exclusive right of governing themselves, as a free, sovereign and independent state, and to alter or abolish their constitution and form of government whenever they deem it necessary to their safety and happiness, provided, such change be not repugnant to the Constitution of the United States. It is hereby deemed necessary jure coronea testi meipso.